Please welcome Dave Bright.
Thank you. Good morning. I have a few examples that I want to share this morning and talk about briefly. There's 4 different scenarios. I've got images of each of them that I'll bring up. I try to make appropriate credit when I can for that. Some of these were taken offline, not original works by me, so I try to make sure I give proper attribution. I do a fair amount of work with artists and arts organizations, so this is an area that has always been of interest to me. And thankfully, there is an active arts community here, and there's also an active public art community here, and also an active graffiti community in Iowa City. So there's no shortage of examples, thankfully, for me to rely on. This first one is spray-painted graffiti that's been applied to an alley wall without the permission of the owner of the property, right? That is a very legalistic way of saying graffiti. It's from an alley in downtown Iowa City. It's taken off of this Iowa City graffiti site, which isn't terribly active, but occasionally has some interesting stuff on it. In this particular context, it helps you to sort of establish the basic framework when you're dealing with, let's say, unauthorized public art. Unauthorized public art, we most call graffiti, usually applied to someone else's property. However, if it's applied to someone else's property, that doesn't necessarily mean that the artist has given up their copyright in it. The owner of the building may own the wall that it's on. They may be able to paint over it. They may be able to, in the works, say, of Banksy or other well-known graffiti artists, cut the wall out of their building and sell it. But interestingly, the artist will retain the copyright in that work. There have been some instances where people have taken images of graffiti, marketed them in clothing campaigns, other things for profit, where artists have subsequently sued them for infringing on their copyright. There hasn't been a whole lot of cases that have reached an end. They mostly settle, so it's not possible to necessarily understand what the outcome was. But in any event, there is an interesting question as to whether or not an artist that applies graffiti to someone else's property has copyright protection. There's 2 schools of thought on that. One is they do, because it meets the definition of a copyright, which you can see down below. The requirements are pretty simple. A work must be composed in a fixed medium. I think that's, no question that's composed in a fixed medium. It's paint applied to a brick wall. And it must be original. Now, I'm assuming for purposes of today that that's an original work, that the artist who applied it to the wall didn't copy it from someone else. If they did, then arguably, unless it's a parody or something else that they're creating, that is an original work, and therefore, that would be valid for copyright. There is an argument that if someone commits a crime, that they shouldn't benefit from the copyright from it. That's an interesting thread that I've seen discussed, where people have said, well, does that mean that if someone is under the influence of illegal drugs and they write a song and the song becomes a hit, they shouldn't have the copyright in the song? I'm not quite sure that we want to go down that route with creative works. That might invalidate some copyrights if that became the position. But nevertheless, I think it's interesting to note that as a threshold issue in certain situations, the artist still retains some rights in something that they did illegally on someone else's property. Sometimes, too, I mentioned there that artists have brought claims against them. There are barriers sometimes to artists bringing claims in these situations because oftentimes they do this anonymously for the obvious reason that they don't want to get caught spray painting someone's building. Also, they don't want their reputation to be tarnished by identifying who they are. Maybe they have a day job, right, and this is their evening activities. They don't necessarily want to announce themselves. I made mention to Banksy earlier. Obviously, if the artist is someone who's well-known, that can change things. A property owner who sees something on their building by someone they don't know might just whitewash it with some paint and move on. If they find out that it's worth some money, they might be calling a structural engineer to figure out how to cut that section out of the wall without collapsing the whole building. Then also, too, these types of situations fall under what's known as VARA, or the Visual Rights Artists Act, or Visual Artists' Rights Act, sorry. that sometimes can apply in these situations, but may not apply here. The second scenario, and again, as I mentioned, there's a lot of these that happen on a local level. This is from a building up in Czech Village in Cedar Rapids. In this instance, this work was commissioned by the owner of the property. It was done by a graffiti artist whose name is Cirrus Fountain. I don't believe that's his real name. This introduces another concept here about works for hire. A work for hire can affect copyright ownership. Here, because the person was an independent contractor and not an employee, there likely isn't a work for hire consideration, and the artist likely retains ownership of the copyright. Now, this property was subsequently sold to somebody else. They decided to change the use of the building. It had been an arts facility before, and they're changing it, I think, to a retail store. And as they started to do their renovations, they noticed that there were some structural issues with the building, including in the wall where the mural was painted. And so, they had a new mural painted. It's their building. They can repair it, they can do what they want to it, and presumably included within those rights is their ability to change that work to another one. Now, there was some outcry in response that they covered up a mural that had been done to honor the Czech history of the area, that they didn't particularly like that being replaced, or maybe arguably didn't like the replacement. But in this particular situation, I'm not sure there would be much protection for the original artist. Number one, because the mural is affixed to the building. It's a part of their property, and they can change it. And secondly, VARA likely wouldn't apply here because the artist was not an employee, they were an independent contractor. And because the work was created under a pseudonym, VARA doesn't offer protection to works that are created under a pseudonym. They have to be created under your name. And that goes back to the identity problem that I was talking about before, where someone might not be willing or able to enforce their rights simply because they don't want to identify themselves as a person who does that kind of art. That may be part of their image, may be part of their reputation, they may not want to get fired. It can be a complicated area for them. This obviously not local. I had to go outside of the state of Iowa to get this one. But this is a yarn. I really like this one. This one's got a lot of different levels on it. So the original sculpture of the bull is an unauthorized piece that was placed there without permission from the owner of the property. The yarn bomb was also applied to it without permission of the owner of the property or without permission of the original artist who did the bull. Similarly, you may recall there was a sculpture of a young girl that was placed opposing the bull at some time. Interestingly, the artist of the bull didn't like that the artist of the girl put theirs opposite his, which I thought was just an interesting irony, that he didn't like other people putting unauthorized art on the same property. Sort of clearly depends on what your perspective is there. But in this particular instance, it introduces some other questions that pertain to the municipality. Does the municipality have a role here? Does New York have to do anything about this? That I have not so young children anymore, but I can imagine my young children looking at that and immediately wanting to crawl on top of that. Obviously, they would probably want to do it without the yarn bomb on it, but let's say they crawled up on it and there was a hole in the yarn bomb and their leg slipped through and they flipped and they hit their head on the ground, right? Instant personal injury lawsuit against the city. You can see how those types of situations can arise when you start to get into different types of public art. And again, you have the copyright questions here. Who owns the artwork? Well, arguably the owner of the real property does because it's there. Who owns the copyright? Obviously the artist does because it affixes to the piece. That starts to take you down the road of what should municipalities do in this situation. Should they press charges against the artist? Do they have a code that even addresses these situations? Many municipalities don't. This isn't something that's necessarily in their wheelhouse. Now, some place like New York, I would expect would have considerable municipal codes on public art, but in other areas you wouldn't necessarily have that advantage. Last scenario, this is kind of my personal favorite. This is a local piece from here in town. This was installed originally where the Biology Building East is located over on the East Campus. At some point, I don't exactly know when, I assume when that building was being built, it was relocated. It's now down in Terrell Mill Park, and I apologize for the quality of the images. I stole these from City of Iowa City zoning documents. but you can see it in that top picture. Now, one thing that I think is interesting to note is it's changed a little bit. That's the original placement, and as you can see now, it's more in a row, and it's more upright than in the original picture there. That introduces another interesting question for public artists, is if someone changes their piece, if someone moves it, if someone destroys it, then they can have claims under the Visual Rights Act. And so here, I think, now the artist is deceased, so it'd be a question of whether or not the artist's estate would have any question in it. And I know that this is, the reason that this is in these public documents is they're considering it being relocated to another spot. So as a part of that, I hope they put it back in its original configuration. But nevertheless, the most interesting part of their discussion has been where should it go, why should it go there, do certain parts of the city deserve public art because they're going through redevelopment, and that introduces other interesting questions about public art in a municipal context is who gets it, where does it go, why should it go there. I'm sorry to have to rush through a little bit, but certainly we have time for questions as we do the panel, so if anybody has any questions for me as we proceed. And then I've got my contact information. It's in the materials too, so if anybody had any questions about any of these things or I could offer any other insight or help into it, I'd be happy to do that. So thank you.
All right, our next presenters are Scott Wallace and Lynn Verschoor. Lynn is the director of the South Dakota Art Museum in Brookings, South Dakota, and she is also a practicing artist and chairs the Public Art Committee at South Dakota State University. And Scott is a professor in the Studio Art program